A very good morning to all of you. I, Karan Bhardwaj, along with my friend Saksham Malhotra and Nirmal Sharma, we are here at Vidhi Talks. Vidhi Talks is an initiative, a brainchild of our chairman Suvir Sidhu, where Bar Council have decided to come up with various interviews and conversations with high dignitaries to take their views to the last man standing in the row who is a stakeholder in the justice dispensation system. Today at Vidhi Talks, we have a very tall man as our judge, as our guest. Tall not because of his height, because he's 6 feet tall. Tall also in his stature, in his modesty, in his simplicity. A very senior member of the bar, Mr. Balram Gupta, senior advocate, said few days back about him that he's a saintly judge. You guessed it right. Our guest for today at Vidhi Talks, organized by Bar Council of Punjab and Haryana, is Justice H.S. Sidhu. I must thank Justice Sidhu that he's here with us today. First of all, on behalf of the entire legal fraternity, sir, I want to thank you that you have given last 3 decades of your life to this esteemed institution, Punjab and Haryana High Court, initially as a lawyer and then as a judge. Our viewers would like to know that how has this journey been? Tell us about your education, about your family, people who influenced you, your law school, everything.
Journey has been a great, very, very satisfying journey. I came to Chandigarh in 1978 after my matriculation from St. Joseph's, Bathinda. Joined DAV College, Chandigarh.
Chandigarh, oh wonderful.
For 4 years I was there. 82 I joined, went on to do masters, joined the profession in 1987. Initially, as I was from a rural background, I joined Dara Singh, who was a top name in criminal law. It was expected that I would start my practice in criminal law. But simultaneously I also happened to join Mr. K.P. Bhandari. He also after some time became the Advocate General of Punjab. Now, he changed my line of thought and what I wanted to do. He was more into service law, constitutional matters, land laws. So I got to work a lot. He used to, in the evening, he used to give a legal proposition, and I used to go to his office at 7 in the morning or 6:30 in the morning. Over 2-3 cups of tea, he would discuss the proposition, then say this is the deficiency, this is the deficiency. Then, so that really got me into working and studying. Another thing he always told me, he says, don't stick to one commentary. Look up all the commentaries on the subject. Only then will you be able to refine the proposition of law, because each author discusses the same thing in a different way.
Yes, sir.
So that is how journey started. Mr. Bhandari was elevated in 1989. Dara Singh stopped active practice, and I was on my own. And fresh from the law school. I had also decided to do my doctorate. The subject of my doctorate was Justice Bhagwati and his contribution to fundamental rights. I had enrolled under Dr. Balram Gupta.
Oh, wonderful.
Never got to complete the doctorate because the profession was reasonably demanding. Initially, one comes to the profession, and that was the era when public interest litigation had just started. So we youngsters were fired up that we can do this. I distinctly remember at least 3-4 cases. One was just 2 years at the bar, 2-3 of us, Mr. Baines, and another colleague of mine who since left to the US, we decided to lay challenge to the 64th Constitutional Amendment.
Okay.
This was an amendment whereby President's rule had been extended in Punjab beyond the period of 1 year. Normally, you can extend the President rule as per the Constitution beyond 1 year only if there is an emergency in place, or the election commission certifies it's not possible to hold elections. But they decided to extend it. Another amendment was made, one amendment, 1.5 years, then 2 years, then 3 years. We laid a challenge to that. We got requested senior advocate Miss Indra Jaising to do it for us. She did it. Ultimately, it was dismissed. And another case I remember was, I read an article in the Indian Express by Tavleen Singh.
Yes.
The MP lad scheme had just been initiated.
A very celebrated reporter.
The MP lad scheme, whereby MPs were given 1 crore discretionary fund to spend anywhere they specified. So she has raised an issue in that this is unconstitutional. So 3-4 youngsters again, we did a lot of research on that, spent about 1 month researching that issue, came to court, relied on various constitutional conventions here and there. Then came to court, it was dismissed, heard no merits, dismissed.
So this journey of heard merit dismissed is continuing for a long time. It's not a recent trend.
We went to the Supreme Court. The Supreme Court says matter not justiciable, dismissed. But subsequently, 15 years down the line, the Supreme Court heard this matter, a constitutional bench heard this matter about the validity of the MP-led scheme, though it upheld the validity. Another case which I remember, a particular minister had been inducted into the Punjab cabinet as Minister of State without portfolio. Now, we did a lot of research again, 2-3 youngsters, Mr. Vance, etc., that this is illegal, unconstitutional, because a man, as the Supreme Court had by then laid down some law that constitutional conventions are also part of the Constitution. So we latched on to that. We went through the British constitutional conventions, as per which we found out that a minister of the cabinet the Council of Ministers as a whole never meets. It is only the cabinet which meets in place of the Council of Ministers. And a Minister of State is called to the cabinet only when a matter pertaining to his or her department is an issue. So we raised the point, this minister will not participate in the meetings of the cabinet. What is he doing? He is being paid without any work. Again, we went through all the constitutional conventions, heard no merits, dismissed. But then, ultimately, we don't know whether a result of this or no, the person concerned was elevated to cabinet status. Because the convention is a cabinet minister without portfolio will go to cabinet meetings.
Yes, sir.
So maybe it helped him to
gain a promotion at least. Yes. Sir, pardon me saying that, you refer to Mr. Bance. Yes. And I have been interacting with Mr. Bance a lot. I know a very distinct quality of him, that wherever he is, he comes for lunch with his wife in the afternoon. Tell us about your spouse,
Mr. Bance,
R.S. Bance, sir.
Yes, sir.
And he comes for it. You please tell us about your family, your wife, your children, parents and everything. That's it just correlated to my mind, and I think we should have some interesting family conversations also apart from work.
Family, my father was not in the legal profession. My uncle was, but he had left. Family, my father was not in the legal profession. My uncle was, but he had left way back in 70s.
Much prior to you coming into profession.
Joining the profession. My family is basically agriculturist, a little bit into public life also. But then that again is a past. 85 was the last.
Was the last election.
A small family. My wife is a professor in Punjab University.
Oh, wonderful. Okay.
So that is that. A daughter, she is pursuing law.
Oh, that's wonderful. So there's somebody who will carry the torch with the flame burning.
Not in the legal, yet studying.
Being a celebrated lawyer, you're working with Mr. Sardar Dara Singh, who's been a very lawyer of a high repute. However, now that tradition of joining an office, staying there for some time, for XYZ compulsory reasons, maybe because of compelling demand of finances and other things, is breaking. What do you say to young lawyers? Because that's very essential. This year, you would not believe that there are 10,000 enrollments in Bar Council of Punjab and Haryana alone. So how this institution of senior junior relationship, their interaction helps, because we see a lot of time a young lawyer does not have a proper guidance, and then he has a continuous burden of procurement also. If you could say something about that aspect.
When I joined the profession, one thing which I was told was that you should have an office, a good office which you can access 24 hours. You don't need permission to go to that office. You can walk in as of right. You can talk to the senior as of right. You can go to his bedroom, discuss any proposition. I mean, if a junior lawyer has that
That's
benefit,
a wishful thinking.
no, we had that benefit.
We had that,
yes.
yes.
That benefit at that point in time. We could access the office, library, use all the resources of the office, the steno, the munshi. They are resources which a junior lawyer cannot afford.
Cannot afford, yes.
And most of all, the advice from the senior counsel. Walk up to him any time without appointment. There was no system of appointment that time.
Yes, sir.
You just walked up, went to his bedroom,
talk to him about
talk
anything
to him
under
about
the sun.
anything at any point in day,
Any
night
point
or
in
day.
time.
And it was always forthcoming.
And there was a continuous response also that nowadays, with a lot of people getting busy into their work structure, with a lot of social media it went, that relationship between senior and junior bar is do you think that is increasing, or it needs to be worked on?
It needs to be rekindled. That relationship needs to be rekindled. There is no substitute to that. This Guru Shishya, it is a lifelong bond. House, no matter where you go, that bond stays.
Yes.
That bond stays. It needs to be rekindled. I think that is what the junior bar is missing today.
That is that.
It is missing today.
And sir, you referred that you come from an agricultural background, you came from rural Punjab. And our listeners would be from rural areas from both Punjab and Haryana also. And if you would allow me to ask this question in a vernacular language, ਹੁਣ ਬਹੁਤ ਗੱਲ ਹੁੰਦੀ ਹੈ ਪੰਜਾਬੀ ਵਾਸਤੇ, ਜਿਵੇਂ ਕੋਟਾਂ ਦੇ ਵਿੱਚ ਪੰਜਾਬੀ ਨੂੰ मौका देना चाहिए, या हरियाणा में हरियाणा को, या जिसकी भी जो भी मातृभाषा है उसके बारे में बात होनी चाहिए. आपको लगता है कि डू यू थिंक दैट नाउ इफ पंजाबी और हिंदी इज मेड कोर्ट लैंग्वेज, और एटलीस्ट इज एक्सेप्टेड इन दैट नॉर्म, would it incorporate lot more people into the judicial field, the participation of a people? Because it could be a situation where somebody in New Mewat area, in far-flung areas, or somebody in Pathankot in a remote subdivision level may have a very good legal mind, but may not have access to language to such an extent. And because the court functioning is limited to a particular language, he is facing difficulty in accessing to it.
So once, if you go across to the districts and the tehsils, the amount of talent that is there
is substantial.
Amazing
Yes.
talent.
Yes.
What they are aware of the practical realities, perhaps people who have directly joined the bar are not.
Yes.
The High Court bar are not. So that is a talent. The only handicap they face is this language. So personally, subject to working out anything, I would certainly be a votary that the regional language be.
Now the judgments are being provided in Hindi. I think even subject to your approval, even a litigant, if he gets to know his decision in his Maboli Punjabi or Matrabhasha Hindi, he would be able to better appreciate and even come to his client in a better way with answers to those things which has gone against.
There may be some difficulty initially, but if it can be worked out,
it must be worked out.
It would be.
And sir, that one thing you said about Guru Shishya relationship, and earlier money was never a part of that senior junior relationship. Nowadays emphasis is being, even the Chief Justice of India, Mr. Chandrachud, said that junior lawyers must be paid good stipend. This thing in our institution, do you think that still there is a lot to be done in this areas where I'm speaking, I'm not that young now, I'm 40, cross that stage, my younger colleagues Nirmal Sharma and Mr. Saksham would talk about it, that seniors need to encourage their juniors with better stipend also.
My experience with my seniors was they were extremely generous. more than what we deserved.
So you are a votary for that they should be paid well.
Yes, they were generous. I mean, more than what we deserved.
Sir, Punjabi जब ਅਸੀਂ ਅਰਦਾਸ ਕਰਦੇ ਹਾਂ, in third part of the ਅਰਦਾਸ ਇੱਕ ਗੱਲ ਆਂਦੀ ਹੈ, ਮਨ ਨੀਵਾ ਮਤ ਉੱਚੀ. When we see you, the bar sees you, you are an epitome of that saying. You embody it completely. But that simplicity, that uh, old school thought of sticking to books, encouraging, जैसे आपने बताया that you have to work on various amendments. These are still news to me. I believe people would not be going to English literature in preparing their cases. How do you think that that old school understanding of literature, keeping that simplicity, is still a way to success in legal life, or this pump and show which has come, swanky cars, expensive watches, have taken place for, I'm not against that, but somehow it also becomes as a road barrier for few people who do not have that kind of material success. What are your opinion about it?
You know, that is, you may be right, because if you go to the bar, on the one hand you have a poor, a person who's come from a village riding a scooter. On the other hand, you have big cars.
Big cars, yes.
Certainly it would be, the person would feel something. Just as in schools, public schools, now they try to introduce that
There should be
some kind of equality. But that is a system, we can't help it now. Somebody has achieved success. He has it.
He has it.
He's come the hard way. Success doesn't come easy in the profession at all.
That is it.
It is a tribute to his or her hard work.
So if you have it, you can flaunt it.
Why not?
That is right.
Share it. People get inspired also.
People, that is also one aspect of it.
People joining the professions because they feel
that it is a lucrative.
Good avenues.
Yes.
The fact that lawyers have good houses, big cars, perhaps that
is an encouragement with people.
Yes.
That is the reason why perhaps 10,000 people have joined legal profession last 1 year.
Yes.
That is there. So, detachment as a judge and as a lawyer is a very important principle. Your personal beliefs are one, and then as a judge, perhaps something else is required. Or as a lawyer also, at times you detach a preposition from your personal opinion. You granted bail to a person who was accused of saying something derogatory to the first Guru of Sikhs, Shri Guru Nanak Dev Ji. And you yourself, coming from a very good family where traditions are upheld, did that ever came in contradiction to your understanding as a personal understanding? You may not personally have approved of that thing, but then felt that need that he could be enlarged on bail. That thing is a big challenge these days as a younger generation. Is that detachment possible, and how to achieve it? It would be our listeners.
Personal beliefs, I don't think, come in the way of your judicial discharge of your duties. There you are guided by legal principles. If something is made out, it is made out. If not, personal beliefs are kept aside.
I was interacting with few law students, a final year student, and he said a client has committed a crime. You know that he has committed a murder. How do you contest his bail application, or what would be your karmas to it? So what is the karma of a lawyer? Whether he should defend that person whom, despite of the knowledge that he has committed that offense, or he should go a step further and do his job of assisting the judge to the best of his possibility, and let the judging thing remains with the judge.
That is what we have been taught. We have been taught it's not your business to judge. Somebody else is given that job. Your job is to defend your client to the best of the ability as per the available legal parameters. Whatever you can put across, you put across. Even if you have personal knowledge, he's done something, but he would be entitled to something. If it falls within the framework and gets some benefit, he gets it. Your personal knowledge is a part. You are not a witness.
Yes, sir. That is also a very vital thing.
You are a professional.
So you should stick yourself to the brief and the documents which you have, rather than having...
Suppose you don't try to mislead or create some evidence in favor, but whatever is there, you can put across, you put across. He is entitled to his legal rights, and that is the tradition of the bar. Anybody comes to you, a lawyer has to accept the brief, irrespective of his or her personal beliefs.
So my next question is that there is a saying that the best judge of the judge is the bar. However, we represent a community of lawyers. Any person who is a young lawyer starting perhaps his career at the age of 24, 25, in judges' corridors, in conversations, what do you think that a lawyer should take care of to be in that thing that he's considered as a genuine lawyer? What are those parameters, those qualities which you think that must be there in a lawyer?
Just happened to read Mr. Nariman some days back.
Before memory fades, if I'm
Before memory fades.
Yes.
He says the lawyer, there should be no whispering in the corridors about any judge. Lawyers should guard against.
That is
because
it.
eventually it will reach his ears, and we are all humans.
Yes. Yes. So there should not be
Yes.
uncharitable criticism in corridors.
Yeah, legal criticism, yes.
Yes.
You are entitled to criticize.
And that thin line between legal criticism and
Yes.
Personal criticism.
Personally, yes. Mr. Nariman warns against it.
Yes, sir. Yes. So a few days back, there was an article written by Honorable Justice Sanjay Kishan Kaul about mental health in legal profession. In the magazine you must have gone through, which is published by Bar Council, its name is very aptly called Council.
Yes.
Council for Council and Council for Council. It talks about mental health. And what do you say about how, because there's a lot of work pressure as a judge, and equally on the other side of the bar, the lawyers also undergo a lot of pressure, and the pressure is from procurement to presenting a case, preparing, managing staff, various aspects. What do you have to say about this particular aspect? Is it being ignored, or is it being unnecessary given a hype these days that mental health is not that relevant a question?
Mental health is extremely relevant. I mean, the amount of stress that a lawyer has, maybe after a certain level there is no stress. I mean, the seniors, they take things in their stride, they have got used to, and the clients also don't question them. But as a junior, you are expected to deliver. There is a pressure to deliver. If you lose a case, it has an effect. If you win a case, that again gets you something. So the stress element is great as far as lawyers are concerned. Judges, I feel, may not have that element of stress. They may have a work pressure, which I think is different from stress. How to cope with that work pressure is something one has to learn. But that stress which a lawyer faces, because young lawyers, bread and butter depends on the result of a case, and a highly competitive profession. So that really needs to be taken care of. These are stressful times. We have been through COVID. Lots of lawyers have had to go back. People who have an establishment here, a house, everything is taken care of. But somebody who has to hire an apartment, pay the rent, electricity charges, etc., it's very difficult.
So what do you suggest? How far you have been? Because all this while for last, I have been myself watching for last 15 years. You've maintained a particular weight also. Despite being enormous pressure as a lawyer and as a work. What do you think? How do you beat stress and pressure? Stress as a lawyer initially, and then work pressure as a.
No, then one has to balance a little bit. You have to keep time for. I mean, life is not all work. You have to balance. That is what everybody says. Balance your work, your family, your health. Everything has to be balanced.
Balance is the key.
Balance has to be maintained. Otherwise, collapse.
Complete collapse.
Complete collapse.
So you referred about COVID times, and COVID times changed legal profession also completely in more than ways which we could comprehend, and especially our bar and this region adopted to it in a very quick manner. Maybe the time demanded it us to be very responsive, and the judiciary and the bar together, hand in hand, the bar and van walked that difficult path and came out of it also with flying colors. My question is that now, with increasing advent of social media, though there is already a concept of open court, whenever a hearing is going on, anybody can walk in and can have a look at what is happening. But what are your views about live streaming of the proceedings of the court?
In a gradual manner, I think it is good. Not every case need be live streamed. I mean, something which is of interest to the general public, like now they have opened up the Constitution bench.
That same-sex marriages case, which is being like that. Yes.
Because every case, I don't think everybody is interested in live streaming, and perhaps may not be desirable also. But important issues, certainly yes, should be.
And again, that second question comes from the COVID aspect also. There's a layman, a last man standing, who may be a stakeholder in a judiciary, talks about the pendency of matters and its disposals. At this need, do you think that alternative dispute resolution, the mediation part, is an answer to it? Or it will be another aspect, a limb of litigation only, because it is being formalized now. Mediation too, there are talks going on between various standing committees being set up, that there would be a statutory framework for providing litigation in certain statutes. Pre-litigation mediation is there. What are your views about these aspects?
So this is the need. I mean, we can't progress without this. Otherwise, the system is collapsing. Unless we have adopted it, it's doing, I mean, reasonably well, and people are accepting it. I mean, over a period of time, people have come to accept this mediation. Earlier, there was some reluctance, both in the courts also, the litigation, public also, but now public is accepting it.
And sir, in this long career, it's been almost last 10 years that you've been a judge. There are cases where there have been sleepless nights, where there is a hunch in the mind that which way, where a brief and argument by a lawyer has gone with you to your home, to your family, and you're waking up and sleeping with that thing, that what should be an answer to that preposition. If you could throw some light about these kind of matters, and how do you deal with that aspect?
These are difficult matters with best of judges. If you go through Cardozo's book, Paradoxes of Legal Science, he has dealt with it. It's an agonizing moment.
So can you repeat that book again for our viewers? Paradoxes
of Legal Science, Cardozo.
Cardozo
is one of the, I mean, everyone should read Cardozo. 3 books or 4 books of his. I mean, we all read The Nature of the Judicial Process, The Growth of Law, The Paradoxes of Legal Science, and Law and Literature. I mean, I would suggest every young lawyer should read all these 4 books. Or at least 2 or 3 of them.
Yes.
I mean, he says, I mean, what agony you go through before you come to a decision, and then you are again not satisfied whether this is the correct one or not. He says, I envy an engineer because he is confident about his product. I never know about the product, what it is.
So in your long career as a judge, in last 10 years, has there been, though I think there can never be an occasion in your court, but our profession is of disagreements. There is always a disagreement. Did you come across that where somebody crossed that line of that disagreement, or how did you deal with it as a judge? And what are your views about it? That, because that is a very essential aspect of bar and bench relationship. That interface which starts at 10 and continues till 4 o'clock. There are occasions and still maintain, because every day that the person who got disagreed, you have to come again to the court next day. So there has to be a bit of a learning for lawyers in this, that how to deal with this thing, how to take no, because a no may not be right, but it is final for them. So what are your opinion about it?
No, certainly, when a lawyer comes, sometimes you have to put across your point of view. All right, you don't agree with him once. No, the counsel is insistent. You again put it across to him by, for this reason, this point is not tenable or acceptable. Again, the lawyer sometimes, after, I mean, not with everybody, but somebody then gets annoyed that my point is not being accepted. Then there is no option. He has the right to be agitated. You just keep quiet.
And you have a right to still maintain that disagreement.
Yes,
that where
keep quiet.
it is.
Ultimately, you write whatever the law permits you. The judge has no, I mean, he does not have the latitude to be angry.
Yes,
that
sir.
is the exclusive privilege of
That many would disagree on that, but this is a wonderful thing that that judge has no latitude of being angry. Say, with increase in social media, I believe you must not be there on any of the social media sites,
No,
but
I'm not.
you're not, and thankfully. But a newspaper or any article on various places, does that happen that a particular opinion in a newspaper, in an editorial, because nowadays there is fair amount of fair criticism also, or at times uncharitable criticism also of judiciary as such and of judges as such, or also a kind of a guidance which comes from various people that what way the court should take. Now, do you think that that interferes with the functioning of a judge while he is dealing with those matters of high stake, where he's coming to a court and he is to decide on a particular issue, and then there is a news about that particular incident and all in a newspaper, which provides a particular kind of information about it. So, in these difficult times where there are a lot of contradictions, which path do you think that should be taken, and how far you have dealt with that kind of interference, or whether actually it is an interference or not?
As far as the news is concerned, that is one thing that I don't think should affect anybody, because each paper or television channel has its own slant. But the editorials, I mean, personally feeling, I mean, such matters do not come to us, they usually reach Delhi or the Supreme Court. But at least I have been greatly influenced by the writings of Dr. Prakash Bhanu Mehta.
Yes, yes.
And various other
Yes,
people.
I write exclusively for a lot for Indian Express.
For Indian Express, yes. And then certain articles in Hindu on legal issues. They do give
An insight.
Great insights.
Great insight as a judge also.
Yes, yes.
So reading remains an essential part even after that also, which is independent of law.
Yes, yes. That gives you great insights.
So, at 62, if you look back, if you would not have been a lawyer and then eventually as a judge, what career would you have taken recourse to? What would have been your calling, not for this? And then comes my next question about it.
I think I would have joined teaching in some university or college.
You
The
like...
subject I don't know. It may have been English literature, it may have been law, it may have been...
When it comes to literature, apart from Cordozo, what do you suggest people should read? Something essential readings for lawyers. Because I can see that you're a very voracious reader, and this side of yours, if you could explore. And
one thing I think, when we joined the profession, I mean, what we were advised was the judgments rendered by the Supreme Court within that first decade after independence, 50 to 60, they are a must read for everybody. Then, of course, there's no end to reading. If you talk of American, Learned Hand is one which everyone should
Learned
read.
Hand.
Learned Hand is one and everyone should read. And of course, we have the autobiographies of all. This is Hidayatullah, this is Chagla, this is H.R. Khanna.
Neither Thorn nor Roses.
Yes, all of them. And I mean, at least 10, 12, everyone should read.
Do you plan to write a book at some point in time? Now you will be
No book.
So what will keep you? Because to say that it is retirement is not a very right word. What would you do after demitting office?
And a doctor, they are always in demand.
Yes, sir.
You are formally in the profession or no.
That's a very good answer for our viewers. That lawyers and doctors are always in demand.
Yes, wherever you go, a doctor is confronted with medical problems, lawyer, people ask you, so one has to keep up to date in law.
Yes, sir. Yes,
that itself is an occupation.
Right, sir. And so, your love about your pets. I have learned that you have pets also.
Only one pet every time.
One pet.
One pet at a time. So,
compassion to pets or non-living these animals at all is much discussed about these days. So,
yes.
And Chandigarh is especially a city
one
where
one must do something if one can for these injured and abandoned animals.
Right.
If one can. Lots of stray animals. People just keep them and then let them off for whatever reason. Now, in the Ukraine war, you see people were running for their lives. They were carrying their pets with them. Very touching, very touching.
Yes. Before we wrap up this interaction, sir, what would you tell to a young lawyer who you perceive has come to your court and is arguing a matter? What would be your advice to him?
The advice is only this, that this is not an easy profession. It is meant for the tough. You have to work hard. be prepared to wait. But then this is what has been said always, nothing new about it. And persevere, hard work, and maintain your health. That's another thing. I read sometime when I started 3 things: work hard, work hard, work hard, maintain your health, maintain your health, maintain your health.
There are 2 very important things.
Very
Thank you so much on behalf of Vidhi Talks. As a lawyer, it has been an honor to share dice with you as a lawyer, and it is indeed an honor to have this wonderful interaction with you. Thank you so much,
sir.
Justice.
Thank you, sir.
Thank you so
Thank
much.
you.